Okay, good afternoon, everyone, and hello, New Jersey and beyond, because this tends to reach a large audience after we're finished today. So welcome, everybody. This group that's associated with this is through the National Institute of Early Education Research at the Graduate School at Rutgers University. And it's really the brainchild of Stephen Barnett, who's the executive director at NEAR. He called me some time ago and said, Mike, we've got to do something for our greater education community, especially amidst COVID. And how do we get the experts in front of us to share what they know? So we started back a few months ago. We also included Penelope Latimer. Dr. Latimer was certainly connected to Rutgers for quite some time with the School Development Council. She also is the former Assistant Commissioner of Education for the state of New Jersey. So she's been working with us to coordinate this panel conversation, not just this one, but over the past couple months as well. With the help of Karen Garver, the former Chief of Staff of the state of New Jersey, and Diego D'Assis and Ernie Landante, we've been able to put this together pretty consistently each week. So without further ado, I do want to move on because we've started with our MDs. We interviewed them and asked them what's going on amidst COVID. We moved on to researchers from around the world. We took a glimpse at what China was doing early on and how they were protecting their children and staff. We went on to early education research. We had school leaders on as well. And now it's time to call the attorney in, So we are blessed and very fortunate today to have David Nash with us. David's no stranger to Rutgers. I did see that you received your law degree from Rutgers
Yes.
School of Law. And there's so many questions right now as we think about opening schools. So we are really fortunate to have you. If you haven't heard of David Nash before, maybe you've heard of Legal One. He is the director there and has been, and is affiliated with more groups than I can count. I started looking at the organizations, NJPSA, NJASA, ASCD, the list goes on and on. Why? Because David has a certain expertise, not just in legal notices and liability. You're a very charismatic person and a well-regarded speaker. So today we are happy to have here. It's like one-stop shop, and we get some entertainment, we get some good knowledge, and hopefully you'll guide us into opening school without any major issues. So, ladies and gentlemen, a virtual celebration for David Nash. Welcome, David.
Thank you so much, Michael. I'm worried you set the bar way too high, but we'll do the best that we can. So it's a real pleasure to be here with you, to have a chance to talk about these issues. In my day job with New Jersey Principals and Supervisors Association, we are constantly working with school leaders across the state to try to help with a million different considerations that we all have to think about reopening. So we have sort of been in an ongoing conversation daily, minute by minute, helping folks think through a whole set of evolving standards.
David, can I start with just a pretty specific question? It becomes increasingly difficult to plan for reopening when guidance changes. So we've seen the ambiguity with the guidance from the CDC, which was a go-to for many of us early on, but then there's other public health requirements that are changing. Any advice just to kick us off with in terms of the legal duty for care for our staff and for our children?
It's a great question. And one of the challenges that we have is keeping up with the guidance that changes. It feels like minute to minute. So part of what we do have to do is try to make sure that we're working together. No one person can possibly know all this. I think one of the keys to being successful, this is a superintendent, right? You have to have a great team around you. You have to empower them. You have to back them up and make sure that they have the resources that they need to do what's necessary. So part of what you want to do as an educator or a school leader is to make sure you've got that systems approach in place so that something doesn't fall through the cracks. We do have to follow the latest standards that are out there from the CDC, from the New Jersey Department of Education, from the Department of Health. we do have to follow our local requirements from the local Department of Health. Every district, as you're finalizing your reopening plans, as difficult as this process has been, the more challenging part of this process is actually implementing, actually following through and making sure that all these things that we said we're going to do, we are equipping people to do, and we are following through and providing the support that we need. So what you don't want to do is expect any one person to be the expert on every aspect of reopening. You've got to spread the wealth. And we have to make sure that we are constantly revisiting, because there is probably not a district in the state that will have a perfect plan. This is uncharted territory that we're in right now. So we've got to take our time to kind of work through that process and build in lots of checks and balances.
You know, in the districts, David, we have more than 60 people right now working on schedules just in one district. We have people, we have a restart committee with more than 25 people on. We have pandemic committees in schools now that are forming with school nurses and building that out. You know, schools really need to just be really collaborative right now. So that's some great advice from you to start off the day. So I'm looking forward to learning and sharing what you have here. I love your disclaimer to start too.
Yes, I think there's probably a few thousand people in the state who could give my disclaimer for me at this point. It's sort of built into my DNA. So of course, as we go today, we're trying to give you the best information we can. The attorney-client relationship is a one-on-one relationship, not the one that you have through a collective webinar. With that said, we do want to try to give you the best information we can. So, you know, as Steve Barnett reached out to me about this session, I stepped back a little bit just to sort of try to think through how do we frame the issue of legal liability, right? It's a very big concept. There's so much to it, and trying to break it down and have it feel a little less overwhelming, I think, is really important. So I thought these were some important concepts to make sure we have some comfort level with as we think through potential issues of legal liability. First and foremost, figuring out what is our duty of care. Who do we need to protect? How do we measure that duty? How do we make sure we're doing what we have to? And what we see in the case law over and over again, where there are potential issues of harm, courts ask constantly, was this foreseeable? Could we have anticipated that this would happen? And did you take reasonable steps to mitigate that risk, to try to do what was possible to reduce the chance of harm? What our courts do not do, and I think this is really important, courts do not expect us to have 100% guarantee that nothing will ever happen. We all want that. We want to make sure that we can protect every person, and I know every educator and school leader works towards that end. We know that's not always possible. So the legal question is whether you're taking reasonable steps to mitigate the potential harm, the potential danger. And are you showing due diligence? Have you done your research? Have you put together the appropriate teams? Are you following up when you need to? Are you being responsive? Because as I said, there won't be a district in the state or probably in the country that has figured this out perfectly, right? I mean, we're in uncharted territory right now. So you have to be nimble. You have to be able to gather information, reflect quickly, and adapt as we go. And when courts see you doing that, even if things don't go perfectly, there is a significant level of deference to the difficult job we have to do at the local level. Shared decision-making is really important, right? If you have one person who is making every decision, not consulting with others, you have one person setting himself or herself up for failure. And for all sorts of individual personal liability in the process, and you're not going to make sound decisions. So shared decision-making has to mean something. You can't just go through the motions of setting up a district-wide steering committee, right? I mean, the state of New Jersey said you need to have a district-wide steering committee to figure out how are we going to reopen. Well, you can't just put a parent on there and not listen to what the parent has to say. You can't put representatives of the various bargaining units on there and not listen to what they're telling you in the process. Yeah, you need a meaningful process. It'll make for better decisions, and it'll make for decisions that are legally defensible. Documentation is something you hear from every attorney, right? If you didn't write it down, it didn't happen. So I'm going to walk through some key areas where we have to make sure we're documenting what we're doing, and then following through on that documentation. And the good news is that we do have statutes in New Jersey, and most states have similar statutes for those who are watching outside New Jersey, that will indemnify individual employees who are acting in good faith and something happens, right? We know that things happen. We don't want individual teachers, principals, superintendents feeling like they are going to lose everything because a good faith mistake was made. So when you're acting in good faith and you've got a sound process, individuals are protected if we do have civil litigation down the road. When we're not acting in good faith, when we miss some key red flags that we should have seen, that's when you could potentially have individual liability. So this is sort of the framework that you want to think about when you're thinking about liability issues.
I don't know if you see me smiling right now because I'm laughing that all I've got to do is apply those 9 areas to every single thing that we do, the 150 things that we're planning for, and then we should be fine. There's no liability.
That's right. That's right. I wish it was that simple, right?
Yeah. Certainly not an easy task. Thank you. Great outline.
Not surprising. What's our number one duty of care? Keeping kids safe, right? And this was a case from a number of years ago. The facts aren't so relevant to what we're talking about today, but what the New Jersey Supreme Court said, and other states have said similar things. It's our job to protect people from foreseeable dangers, especially students, not just students, but students first, whether they arise from our careless acts or intentional transgressions. So it doesn't have to be that you intended to harm or you careless in the way that you were moving forward. So as you think about our duty of care here, we start with students. We don't end there, right? I mean, we have to make sure that we recognize our duty of care to every staff member in our buildings. And we know we have staff members with underlying medical issues. We know that we have parents who might have their own issues as well, who obviously interact on a regular basis with schools. You might have other visitors coming into that building. So we have to recognize the duty of care we owe to all of those individuals, which is part of the reason that an appropriate, credible screening process really matters, right? One of the concerns I have, frankly, with the Department of Education guidance that has come out, and no criticism, I mean, this is a huge, daunting task to put together guidance for school districts. It might leave a little too much wiggle room on the screening process side, right? When you read through the 104-page document, there's a suggestion that you could simply have a visual screening of people entering the building and figure out who might have coronavirus. Any doctor you speak to would say they couldn't possibly do that. And they have more training than any of us on these issues. So you want to think through actually a credible process that will allow you to meet that duty of care that you owe to everybody involved in the schools. And it's set in a few different ways, right? We know we have federal law, we have state law, we have local requirements, which are equally important. Some districts in a number of areas are going above and beyond what's required under the state guidance. But that now has become your duty of care. You need to live up to the reopening plan that you've adopted. And then we are also looking at best practices. In this area, frankly, we're looking as much at expert guidance as we are at best practices, because we have best practices for some comparable issues. We don't have a best practice for this, right? So we don't have a great roadmap that tells us all the things we need to do. And the problem is, if there's a breach of the duty of care, there's plenty of responsibility to go around. It's not any one person in most of these cases who's answerable. Usually you have systemic breakdowns. that's where we end up with issues, because you want to build in those redundancies so that you're not overly relying on any one person. So as you think about the duty of care, I mean, this is just a snapshot of the last couple of weeks, right? And some of the standards that have changed. So it seems like an eternity ago, but a month ago, the Department of Education came out with the road back in New Jersey, laying out sort of the guidelines for what districts need to do to plan for reopening. Other states have done the same thing. So that lays out part of our duty of care. You read through that document and there are requirements that we need to meet. And then there's other important considerations that are laid out that we should be seriously analyzing. The CDC has been revising their standards. So they've updated their standards for what is effective cleaning and disinfecting just on July 22nd. The Department of Education has updated their guidance and put out new guidance about the rights of parents. The rights of parents to choose to have their child educated virtually, and the processes that districts should follow as they're putting that in place. And the CDC has updated their overall guidance with lots of additional pieces of information that came out July 24th. And as I said, every district is going to have a document that you need to abide by, and every district has to have that into your executive county superintendent in New Jersey by early August, so that we're ready for reopening. I do want to stress, when you're thinking about legal liability, there's certain phrases you want to pay attention to as a New Jersey district. In that road back document, it talks about anticipated minimum standards. You might as well take that phrase out of requirements, right? Those are really the requirements that we must meet as part of reopening. The reason they use that phrase, frankly, was that the situation could change. It's very fluid. And there might be a new set of anticipated minimum standards that we see the day before schools were set to open. So that certainly is possible. We do have new policies and protocols that districts have to put into place. So you read through New Jersey's document and you see very specific references to new policies over and over again. I think in some places, the Department of Education said policy where they really meant protocol. But until the state of New Jersey says differently, I would take that language very seriously and look to have your Board of Education actually adopting policy. Don't assume the state of New Jersey was wrong, right, in using the wrong terminology. I would be incorporating what they say you need in your policies into your policies. And then having these meaningful committees at the district level, at the school level, and making sure all those pieces are in place. If you don't consider these key questions, your liability can skyrocket too, right? It's a 104-page document that the New Jersey school districts are looking through. You know, as we said, other states have similar, very long documents for guidance. The New Jersey document says, in everything you do, think about the impact on these 4 questions. And that certainly influences the duty of care that we have. So in our practices and protocols, are we going to be encouraging social distancing, or are we going to be inadvertently having kids too close together? So for example, kids come in from outside, maybe they were outside at recess, and in New Jersey, we read through the guidance and we know that students are supposed to come in and they're supposed to wash their hands. And you tell students to do that because you paid attention to the guidance document, but you don't pay attention to the fact that you've now got 15 students all in the restroom at the same time. And now you've got a different issue because you're supposed to also follow the social distancing protocols. Or you have kids passing each other in the hallways because we haven't tried to think through how to make this a one-way street as much as we possibly can. So you want to think through the practices you're putting in place. Will they help with social distancing? Will they limit unnecessary contact between students? At the elementary level, that's much easier. You can, for most of the time, you can keep kids in smaller groups and keep them together. That gets more complicated in middle school, probably becomes impossible for many kids in high school, where you're going to have different classes and students are going to have to move around. But you want to limit that as much as possible. So you want to show you've thought about that. The hygiene practices piece, you know, it's a simple concept, but it is a complete change in how we operate. A student coughs in class and sneezes. This guidance says that student needs to, at a minimum, immediately use hand sanitizer for 20 seconds. More preferably, they would wash their hands for 20 seconds. Getting every teacher to follow that guidance is a huge task in and of itself, that one particular item, and getting folks to take it seriously and do it on a regular basis. And as we think about all this, we have to think about mental health too, right? I mean, there are fears and anxieties that all of us have right now. I'd be worried if somebody didn't have some fears and anxieties. So we have to think about that for the entire staff, and then we have to recognize certain vulnerable populations who might have underlying mental health issues or underlying medical issues, and their fear and anxiety is through the roof right now. And thinking about what individualized supports are we providing for those kids, because it's very foreseeable that they're going to struggle. And because of that, we need a plan. As I said, courts are really understanding if you don't have a perfect plan. They're not so understanding if you didn't think about the issue, when it's an issue that we could see coming.
You know, David, we had one of our restart meetings, we had some high school students that were on our restart committee. And after we went through a series of protocols that would change, you know, what a school transition looks like in the hallway for high school children, what it looks like on the bus, what it looks like in the classroom. So the high school student, as I would expect, said, Dr. Salvatore, so we can't talk in the hallway. We have to be spread apart. We're not going to have lunch together. We can't even talk on the bus. He said, why would I ever want to go to school? And that was from the words in the mouth of a high schooler who's a senior. But I also think many people are feeling very similar, that, wow, school's going to change quite drastically. When you remove that social component, schools really changes a lot.
I mean, that's a great point. And it's not as if this concept is new to us, right? I think we have learned over the years, when you're dealing with student discipline issues, for example, it's much less effective if you spend all your time just telling kids what they can't do, right? What do we do to reinforce positive behaviors? What do we do to reinforce safe ways that kids can still connect with each other? There is this human need to connect with adults, with other kids, and we have to find other ways to do that that kids will buy into. And that's part of the challenge here, is not just saying, don't do this, don't do that. If we spend all our time just saying don't, kids are going to be very tempted to figure out a way to do, you know, give them something else to actually do. As we think about these issues, we have to think about those who have underlying medical conditions. And that's another example where the standards are evolving. When you read the guidance document that came out by the state of New Jersey, June 26th, there was a list of conditions that could make you more susceptible to severe illness if you can track COVID-19. That list is growing. You look at the CDC site now, and there are many more conditions that are on that list than we had back on June 26th. So we have to take the time to make sure that staff and students fully understand if they are at greater risk. And if they are, we have to think through reasonable accommodations for students or staff members. So that process, I think most districts are recognizing this. That process needs to start now. As a superintendent, you don't want to get to the day before school starts and find out that half of your staff have serious underlying medical issues and really can't be in school. Right? You need to make sure that you're thinking about that well in advance and thinking through, how do we address that particular set of issues. So we have to show that we're communicating with students and staff, and that we are open and willing and able to provide reasonable accommodations. I thought it'd be interesting to just give one quick example of a non-COVID case. We don't have COVID cases yet, right? But a non-COVID case that sort of drives home the point of the duty of supervision that we have. So this was a case, just to not get lost in the weeds too much. It was a case that a lower level court had essentially been ready to just throw out, to dismiss, saying that you really can't sue a school district for it. Things happen in school. And the plaintiffs, the parents of the student who was severely assaulted in this particular case, appealed that decision. And New Jersey's appellate division said, hold on a minute, they might have a case. So that's sort of the legal framework. I don't want to get folks confused on that first bullet point. The point is that there is an arguable legal argument here that perhaps there was liability from the school district. And as you think about that, let's look at the facts of the case. It was the last day of the school year, a number of years ago. You see how long some of these cases take. The case took 7 years to get to the appellate division. The incident happened June of 2011. Appellate division decides in October of 2018. But it was the last day of the school year. Technically, students were in physical education class. Really, they were outside unsupervised. And there were no adults nearby. So is it foreseeable if there are no adults nearby and students are outside that something can happen? It is. So a female student and 2 male students left the playground. There were no adults noticing that. They entered the school. They didn't have any hall passes. The school's policy was you need to have a hall pass. Nobody noticed that or said anything. Female student approaches the girls' bathroom and she's asked to enter the boys' bathroom. She does. She makes a bad choice, goes into the boys' bathroom, but then she is sexually assaulted. So there was expert testimony. We see that in cases like this. And what did the expert testimony say? That if there were reasonable measures in place, we could have prevented this from happening. So those reasonable measures include having adults supervising what's happening in the hallways, supervising what was happening outside, and actually having a credible physical education class going on, preventing free access. There were cameras that covered the hallway, but there was no evidence that a staff person monitored that area to make sure that something didn't happen. So the court stressed in this case that the supervisory duty extends to foreseeable dangers from the careless acts or intentional transgressions of others. That same language I mentioned before, but that includes ongoing supervision of kids. So I wanted to just give that case as an example, because we know that if we're not properly supervising what kids are doing in class, during recess, in the hallways, as they go to the restroom, there are a lot of foreseeable dangers that will happen related to COVID-19. And these are foreseeable dangers that we wouldn't have thought twice about a year ago. Kids not wearing a mask, kids being too close to each other, a kid sneezing or coughing near another student, and no steps being taken to follow through. So it doesn't have to be anything like this horrific incident that I laid out. It's going to be much lower level behavior, but it's very foreseeable. And our courts are going to expect us to have supervision to deal with that sort of issue. As we think about foreseeable risk and harm, we think about this in layers, right? There's the foreseeable risk and harm to everyone. Anyone could become infected, right? So we have to show reasonable measures school-wide. Anyone could deal with emotional harm because of increased fear or anxiety. So we have to show reasonable supports school-wide. Then we think about those who are at greater risk of infection. And that includes, for example, a school nurse, right? I mean, by definition, you have people coming to you who are showing symptoms. They might have the illness. They're going to have a greater risk of infection because of the amount of exposure they have to people who are symptomatic. Or somebody who is involved in screening kids and others as they come into the building. You're in contact with many more people. So what measures are we taking to reduce the risk? Like enhanced PPE, like making sure that those individuals have face shields, not just a mask, have gowns, have gloves. And then we have students and staff at greater risk of illness or death, those with the underlying medical conditions. And then we have other students who are at greater risk of harm due to pre-existing issues unrelated to COVID-19, right? I mean, you think about the world pre-March of this year, and we have all become very attuned to kids who are struggling with substance abuse, kids who have underlying mental health issues, kids who have had traumas in their lives, and making sure that they're not falling through the cracks while we're dealing with COVID-19 and reopening. We can't forget all the safety nets we have to have in place for other students that we already knew about. We also know that there has been bullying linked directly to COVID-19. That's foreseeable. Asian students have been singled out and stigmatized and harmed and somehow blamed for the virus. Kids who have tested positive have been singled out for having tested positive and have been stigmatized and had a horrible thing said. And we know at the same time that we're dealing with this issue, we have a dual pandemic that we are struggling with worldwide, the issue of racial injustice. And to their credit, kids in New Jersey are very civically engaged, right? So is it surprising that you might have a group of students who decide they want to organize a protest to protest racial injustice that's happening in our state, in our nation, in our world? That's foreseeable. After Parkland, we had kids who wanted to protest in New Jersey and across the country, and school districts worked with them to make sure that it was done as safely as possible. So you want to anticipate the issues we can anticipate, show you're taking some steps. Again, courts don't expect you to be perfect, but they expect you to show that you've thought about these issues and you have a plan to try to deal with it. Reasonable mitigation. That's a big part of thinking about legal liability. So we know there's going to be a virtual option, full-time virtual option for some students. That's a reasonable mitigation measure for some students who have very serious underlying medical issues, and despite all our best efforts, the risk is just too great. It's also something that's available because a parent might simply have too much fear and want their child to be educated virtually. New Jersey's made that clear. It's going to be a reasonable mitigation measure for some staff members who are able to perform comparable duties virtually. Increased or full-time in-person instruction for other students is going to be a reasonable mitigation measure because you have a student who is struggling with mental health issues, struggled mightily while we've been closed. And while we're triaging and thinking through the kids who might be completely on home instruction, we're also triaging and thinking about the kids who might need to be in every day and identifying those students. Enhanced PPE, as we said, is critical. Training. We're asking people to do things they never did before. So you're not going to have 100% compliance, but if you at least provide ongoing training, you're doing your part. And by the way, it's not just training by school staff. You should be sending information home to parents so that they can work with their kids before the first day of school comes, right? There's a lot of things that parents can do over the next 3 or 4 weeks to work with their children to get them used to new protocols. And then alternative schedules, assignments that reduce risk. You might have somebody who has underlying medical issues, but they don't want to work from home. They want to continue to come to school. And you want to think through, how can we make this safer for you? So as we think about all this, due diligence really matters. You want to show that you had good procedures in place. Show that you had meaningful stakeholder input into the committees that you formed. Show that the committees looked at, studied the Department of Education document, the Road Back, studied the CDC guidance, Department of Health guidance. As we are implementing, you're going to have to be ready to show that you can respond in a timely fashion. So a big part of that is not having a school where every decision, every moment has to be made by the school principal, or a district where every decision, every moment has to be made by the superintendent, right? The whole thing will bottleneck if we don't empower other folks to make decisions and give them, the backup they need when they're making sound decisions that you have to make on a regular basis. And then we better show that we're ready to adapt. Because as we said, none of this is going to work perfectly. A good example from a number of years ago, the LW versus Toms River case. It was a bullying case. Student was bullied starting at the elementary level, continued into middle school, continued into high school. And the parents sued. And it was really a landmark case. Part of what the school district said in their defense was that every time we found out about a bullying incident, we followed our code of conduct. We didn't ignore it. We imposed the consequences that our code of conduct laid out. So it's not our fault that it continued because we tried. What the New Jersey Supreme Court said was that it's not enough to just keep doing the same thing over and over again and expecting a different result. right? If you're doing the same thing over and over again and the same student is being targeted by dozens and dozens of kids over multiple years, something isn't working. So it's not good enough to just follow a broken process. You need to think systemically, what do we need to change? What do we need to do differently? So you've got to be open to that and build in the process so it actually happens.
You know, David, in one of the scenarios with planning that comes up, and it's around the adaptability of the district. There's so many people who are seriously working on building out 3 plans, a real remote plan, whether you're starting that way or eventually navigating back to that, a real hybrid plan, and then a full return plan. Everybody's working on those, but then the adaptability to be able to navigate between the two. So if you start face-to-face and you have some anxiety or stress related to that, and you feel like you need to go back to remote, we're all developing those protocols around that concept of adaptability right now.
Yeah.
Pretty interesting.
That's so important. And just another example of that could come up, right? When you really delve into the CDC guidance, and I'll confess, a year ago, I didn't know half of this, right? I didn't feel the need to delve that closely into some of the CDC guidance that was out there even before this. But one of the examples, if you have somebody who does test positive, who's been in your school, right? Now the CDC guidance says that you need to immediately close off every area of the school that person was in. And the best practice is to wait another 24 hours before you even start the cleaning and disinfection process. So that's for one case. Think about a student or a staff member who, walked through most of the school during a day. Really, what that's going to mean is that we're going to have plenty of situations where schools have to be closed down on a moment's notice. And it's going to happen, and we're going to have to be ready to switch the next day to fully remote, right? It's very foreseeable. We're going to have this. And again, it doesn't have to be a perfect plan, but you need to have a plan to show, all right, this is what we do when, this was going to be an in-person day. Now it's remote for everybody. And this is our plan B. So each teacher should have a lesson plan so that their in-person classes could be fully remote if they need to be that next day. So documentation, of course, is huge. Right. You're going to have all sorts of required trainings over these next several weeks, and then obviously well into the fall. Make sure there's no doubt about who was there at your trainings, virtually too, who was there virtually. You want to make sure that there is a clear record of that. I hate to say this, but we're going to have progressive supervision, right? Despite all the training, despite all the support, you're probably going to have some staff members who just don't do what they need to do. And it's not going to be enough to keep sending that person for training. They're endangering potentially the health and safety of themselves and others. So once you've provided the support, we're going to have some cases where we have to start documenting and moving through progressive supervision, unfortunately. Same thing with students. You give them all the training and support and make sure they understand the rules, then you're going to have to enforce it. Kids aren't going to take rules seriously if they know there is no consequence if they're violating the code of student conduct. So we're going to have to rethink that code of student conduct and have some meaningful consequence for that student. Now, as I say that, I don't think districts are going to want to jump to suspension. Right? I mean, you already have kids who are going to be out half the time, 2/3 of the time on remote instruction. So we probably don't want to leap to suspension as a consequence. We probably want to think more about restorative justice and different types of approaches. The key is to have some sort of a response, some sort of a consequence that hopefully over time changes the behavior. And you have to be ready to document. Now, let's say that you have placed an order for all sorts of PPE and resources, and they haven't come. You want to be clear in all the steps you're taking to try to get those resources. And it's not your fault that the manufacturers, the vendors drop the ball, but you've got to show that you're making that effort. Same thing with personnel, right? We're going to have shortages of personnel. It's going to happen. But we have to show that we've at least put in place a plan to cover areas where we have teacher shortages or administrator shortages or nursing shortages, right? I mean, a school nurse gets sick, it's going to be difficult finding a replacement nurse. So you've got to be ready to show that you're pretty aggressively reaching out. And again, courts will understand that you might not have somebody immediately that day, but you have to show the process that you're following. This piece on shared decision making is obviously very important. You know, we're going to ask people to take on some new responsibilities that they didn't have before. So as we're asking people to do new things, they should be part of the conversation. Right? I was working with one district where the district has in place a very aggressive set of cleaning protocols that their custodial staff will be doing, but they also know that many teachers want to do more. So without mandating it, they are providing additional cleaning supplies for any individual teacher who wants them, and giving that person some basic training on what the cleaning protocols are if they want to do any additional enhanced cleaning. So it sort of becomes a win-win. You're doing what you need to do, but you're allowing people to go further, but doing it the right way. Because if you don't do that, what are you going to have? You're going to have individual teachers bringing in their own stuff, doing it their own way, and maybe sometimes not very safely. And that creates a different set of issues. So having that conversation is very important with every stakeholder group. The last thing you want is for your Board of Education to be surprised and say, hey, I didn't know we were doing that. They're going to have people from the community constantly coming to them over these next several months. Now, and it feels like another life, but at one point in time, I was a school board member, right? And I had lots of folks who would come to me and expect me to fix the issue right on the spot. And sometimes the description that was given to me as a board member wasn't very accurate about what the issue really was, right? So I learned I needed to gather more information before I started saying, hey, what are you doing? Why is this? Why did you do that? There's an excellent chance that wasn't the full picture. So your Board of Ed needs to understand that, and you need to have a level of trust that you can have ongoing communication between superintendent and board, so that we don't have unsubstantiated rumors sort of becoming self-fulfilling prophecies and getting out there. And I know you appreciate that as a superintendent, that communication is crucial.
Absolutely, very good.
Every day. I thought that it was really important as we're having this discussion that I stress the indemnification piece. Right? Individuals are doing the best they can. They're working really hard. Everybody wants to keep kids safe, keep their colleagues safe, keep themselves safe and their families. If something happens, if somebody becomes sick, despite our best efforts, if there is litigation down the road, what New Jersey has said, and most states have similar provisions, that if you're acting in the course of your duties and there is some harm and somebody tries to sue, you will individually be indemnified. If there's a civil action brought, the Board of Education will cover those legal fees for you. They will cover any judgment against the individual because you're trying in good faith to do your job. So that's a really important concept. Same thing is true. It's a little different, but for criminal actions, if there was a criminal complaint against an employee, once that complaint is dismissed or there's a favorable disposition, those costs are covered as well. Now, as I say that, there are some things that aren't covered, right? You show that a teacher was willfully causing physical or emotional harm to a student. That's not something that arises out of or is in the course of their job. That's way outside the realm of their job. So the intentional acts that cause harm are not going to be covered. The reckless acts that cause harm, where you might not have purposely been trying to hurt somebody, but there was an excellent chance it was going to happen and any reasonable person would have known that. And this was a high level reckless act. Those are often not covered either. And that's where you start getting into punitive damages. So my hope is that none of you have that employee in your district, right? But in those extreme cases, somebody could have individual liability. But short of that, you're acting in good faith, you're going to be protected. I wanted to give folks a tool I was very impressed with this. We just did a training Tuesday of this week on thinking through reopening protocols and how do we safely deal with cleaning, deal with cleaning our buses, tracking our supplies, reopening our buildings. And the Lawrence Township School District, I want to give them a shout out in New Jersey, did a wonderful job at putting together a planning tool that really thinks through every aspect of the nuts and bolts of building cleaning, bus cleaning, all of these procedures. So I have a link in this PowerPoint to that planning tool. Tom Eldridge is the business administrator there. He was just named Business Administrator of the Year. I see why. He did a great job putting this together. So it's just an example of a district that's engaged in a very thorough process, and they're not done, obviously. It's an ongoing process, but it's a nice tool for folks to think about all these issues.
That's great. Thank you.
I want people to be aware too of other resources, right? We have at Legal One, we have since on March 18th, the day there was a statewide closure, we offered a free webinar on issues to think about as we were moving into a period of virtual instruction. And we didn't stop there. We've been doing them constantly since then to try to help folks in the field. So I give you a link here to all of those free webinars that we offered. We have a number of other resources that we've identified as well for folks. These are some of the pandemic response series webinars that we did between March and the end of May. And then starting in June, we have a different series at the link that I just showed of more webinars to try to help folks with all these reopening issues. We also did a 2-day pretty intense institute. So we had great speakers, including 2 wonderful superintendents, Dave Adderhold and Scott Rocco. Like you, they are deep thinkers, right? And they have spent a lot of time very quickly putting together plans and identifying all the different aspects that we have to think through when it comes to reopening. So we really had a great set of panelists for those 2 days, and that resource is out there too. I feel like I've been talking a lot, so I'm happy to respond to some questions.
Oh, great. I think the information that you provided, just as an overview, is really, really wonderful. I do have a couple questions.
Yeah.
So there are a couple concepts that you mentioned, particularly vocabulary. We all understand, it's easy to conceptualize negligence. It's easy. You fail to do something properly, recklessness, we get that too, purposely or intentionally you don't do something. But there's this term out there, reasonable. Okay. So one of the questions that came in from Andrea, and this is a term used all over the place in terms of legal jargon, it's reasonable accommodations, right? So what are some of the reasonable accommodations for staff? Because I'm going to tell you, I did a survey for staff, we have about 1,000 employees, almost 90% of the people filled it out. But within that, there were a chunk of people, about 1/6 of our total population, who said, I'm going to need some accommodations.
Yeah.
Now, the interpretation of reasonable, some were clearly not reasonable, but some were reasonable. When you're talking about health, right?
Yes.
And maybe if their job doesn't require them to actually be physically here.
Yeah.
Talk to me about what are reasonable accommodations. I know it's specific to each position, right?
Yeah, I'll think of it. Let's think through an example or two. So let's say you have somebody who's part of your custodial staff who has very clearly defined underlying medical issues that are on that CDC list, right? So, and they've got medical documentation. There's no question they have those particular issues. And that person says, I need a reasonable accommodation. I want to be working virtually. So what our courts have said is that you have to analyze whether the request creates an undue hardship. Mm. It's really impossible to do that particular job virtually, right? You're not going to be able to do that cleaning. So what might be a reasonable accommodation? Perhaps that person is working a night shift where they are exposed to far less people. And there's a different time. Perhaps that person has a face shield, has a gown, has gloves, has additional PPE that's being provided that you don't provide to every single staff member. So that's an example where, the person asked for something that couldn't be provided because you can't really do any aspect of the job virtually for that particular role, but something could be provided. You could give that person a different schedule. You could limit their contact with other individuals. You could give them enhanced PPE. That's the sort of thing that you want to think about for a lot of different roles.
So I'm gonna apply it to the most difficult one, because when you have free legal advice, you might as well use it.
Sure. Which I already said I wasn't giving, but okay, as a hypothetical.
But let's just consider this. I've got a teacher who might have an underlying health issue, okay? But maybe it doesn't meet the 8 criteria of the CDC, right? The cancer or the immunodeficient or something.
Mm-hmm.
But they are not healthy overall if they evaluate themselves. And they're of a particular age where they're more susceptible to a severe reaction of COVID. But they're a classroom teacher now. And if 50% of the students are coming back, you've reasonably accommodated the social distancing component, if you're even considering certain social distancing for some grade levels, right?
Mm-hmm.
Because preschool, is it even realistic to socially distance a preschooler? Probably not. I don't see so. But if you've done those things, and is it reasonable to say you've reduced the class size, provided PPE, you're providing professional cleaning? Is that reasonable to say that person should come back to work?
Good question. So there's no simple answer to that, right? I'm going to start with it depends. Every good answer starts with that from a lawyer. It depends. So you have to look at the overall universe of your district, right? Let's say that, I'll make an example that's maybe not realistic. 5% of your teachers are asking to work virtually. My guess is it's going to be a much higher number, but let's just use that as an example. 5% of the teachers are asking to work virtually. 30% of your kids, the parents are saying, I want my child to stay home and learn virtually. You probably could figure out through scheduling how to focus the work of those teachers with those kids who are going to be home virtually and have them productively doing their work. So it depends on the district and the overall numbers that you have. Let's say you have, 40% of your teachers who are making the same request. And you have to do a little bit of a triage approach, right? So you get the information you can from that individual, from their doctor. You get a sense of the severity of what you're dealing with, and those with the most severe potential reactions are going to be assigned virtual duties. Another percentage of them will receive enhanced PPE, perhaps be allowed to have a different entrance. They come into the building so that they're not crossing as many people. Perhaps have some, enhanced access to hand sanitizer and things like that. So you think through a different set of accommodations for some subset of that population. It's not going to be the same answer for every individual person because the system has to work. And you're allowed to say under state and federal law that the particular request would cause an undue hardship. That's a concept that's built into the statute itself, but you can't just say it. You have to show you went through this process.
So one of the questions that keeps coming up in circles of superintendents is really about, so how do you select? We're not medical professionals, right? And we don't really want to know everybody's medical history because, that's pretty confidential information that we don't really want to toy with. Is there a reasonable selection process to vet out or to provide those options, and where do you start? Do you start with your most susceptible?
Yeah, it's a great question. So you do want to be very careful as you navigate this process. So technically, this, technically you're not entitled to somebody's medical diagnosis, right? What you're entitled to know is that whatever the underlying medical issue is, this is the impact it has on their ability to do the job. So as you're having those conversations, you can press for clarification And oftentimes you want to get your school physician involved. You can press for clarification about what exactly is the impact on duties. And not all conditions are equal. Somebody has mild asthma versus somebody who has severe immunocompromise. Very, very different situations. They're both on the list. But you can start to triage those issues by looking at the level of risk. And one of the things you can see in the CDC guidance, they actually have 3 different sub-bands when you look at their list of underlying medical conditions. There's those that we have conclusive evidence, there is absolutely no question at all. That could be one set of categories that you could triage. There's a second set where there is mixed evidence, and some of it contradicts each other, but they're still on the list because there's some evidence. Then there's a third set that just has limited evidence, and there hasn't been a lot of study. So another way you might triage, which of the staff members are the ones that are in the conditions that have conclusive evidence versus mixed or limited evidence.
That's a great recommendation. That's great. I have, we only have a couple more minutes, but I do have another question that came in, and it was talking about reasonable accommodations, but not necessarily for themselves, for them taking care of somebody else. This is coming up a lot, whether they live with their parents, their spouse is sick. And again, I know it depends, right? You're going to start.
Of course. With that, right? Yeah, but it's also different terminology you want to use, right? Mm-hmm. Because now you're not talking about, when you talk about reasonable accommodation, that's really talking about the individual and their own issues, age or medical condition. When you start talking about the need to care for others, now we have a set of rights under New Jersey Family Leave Act, under the Federal Family and Medical Leave Act, and there have been some expansion of those rights with legislation that was linked to coronavirus. So that's what you want to look at there, are the rights that individuals have under state and federal family leave that have been enhanced at both the state and federal level. So one of the free webinars that we have in that list that I gave you was just on the issue of reasonable accommodation and analyzing leave requests, both for the individual and to care for a family member or somebody else. Very different analysis.
Great. And I just want to repeat this because this is how I heard it, that the reasonable accommodation is for you and your work situation. It's not specific to your spouse or family or people who live in your environment. So that would be under a Protected Leave Act and those requirements, right?
Yes, yes. And there are some forms of leave where you're still receiving full pay. So for example, there's some expanded rights to use your accrued sick leave or emergency sick leave. We've got specific provisions for that. And there are some provisions in state and federal law for partial payment for a period of time as well. And we have family leave insurance as well that can cover the cost that otherwise wouldn't have been covered, or a portion of that cost for a time somebody is out. Mm-hmm. So it's very layered depending on exactly what you're asking for and how long you're asking for it.
Great answer. So there is one more term that we didn't really get to talk about too much, but it is a legal term that comes up a lot in terms of discrimination. And this is an important piece here because now you have a virus that impacts certain ages differently.
Yes. So that's a great question. When you're thinking about the rights of an individual who is, the CDC has set the number at 65 or older. Right. There have been some other studies setting a much lower number, 60 or older, 50 or older. The current sort of official list from the CDC says that you have an enhanced risk of severe reaction if you're 65 or older. So there's going to be some debate in the litigation over exactly what that number is. Most districts are probably going to rely on the CDC number, which would be understandable, of 65. So you would have protections under the Age Discrimination in Employment Act. So even though you're not entitled to a reasonable accommodation under the Americans with Disabilities Act based strictly on your age, if you fail to engage in a similar process, you could face a claim under the Age Discrimination in Employment Act. So I would basically go through the reasonable accommodation process for somebody making a request based on age, even if there's nothing else linked to it, if it's just age. Obviously, if there's an underlying medical issue, it's a simpler analysis. But even though technically you don't have to go through what's called a reasonable accommodation process, it's the same process. So I would still try to go through that interactive process for somebody making a request who's 65 or older.
The last question of the day here is from Eric Rodney from the New Jersey Department of Education. And he's asking about, in terms of, I believe, in indemnification for a federal shield to be enacted to insulate districts. You have any words of wisdom there, David?
Yeah, I mean, there is debate about this, right? So Congress is having some discussions to, there's a lot of different proposals that are out there right now for additional relief for states across the country. There's also a bill in New Jersey that's been introduced that would provide some additional protection against liability. So the concept, I think, does make a lot of sense. We are in uncharted territory. We're working very hard to figure out what the standards are, and some reasonable protection for people acting in good faith, I think would make a lot of sense, but it hasn't been enacted yet. Right? So the indemnification that I talked about is all that we have right now. We don't have that additional layer of protection.
Well, that was great. David, you answered so many of our questions and you guided us through. If there's any questions that weren't answered, NEAR does a great job of trying to, the team at NEAR does a great job of trying to reach out, connect people to those answers. So David, we don't want to take up any of your time. You were great. We all learned something today. And I think we can even put out some of those resources you mentioned. I know there's people right in my office that would love to participate in some of those free webinars that you've been doing.
Thank you so much. It's great to be here with you, and thank you to everybody in the field. We know how hard you're all working. We know how much you care. Just know that you're not in this alone.
Thank you. All right. Have a great day, everybody. Thank you again, David Nash, everybody from Legal One. Great job.
Thanks, Mike.
Have a great afternoon, and I believe we'll see you next week. We'll look out for our emails. I'm not certain of the topic right now, but as soon as we get it, we'll be putting those out.
Thanks, Mike.
Bye-bye.